Hey everybody, John Skiba here from the Consumer Warrior YouTube channel, and in this video we're going to talk about bankruptcy, and specifically if you're considering bankruptcy, I'm going to talk about 4 considerations that you have when determining when you should actually file your case with the court. These are super important things you need to think about. You can't just dive into that process, and so we're going to go over all 4 of them today and kind of help put you on the right track. But if this is your first time here to my YouTube channel, please click subscribe, check on that little bell. That way you'll be notified each week when I put out new videos that'll help you deal with serious debt problems. All right, so let's talk about bankruptcy. If you're considering a Chapter 7 bankruptcy, if you're finding yourself that, hey, it's now time, I'm in a debt situation I can't get out of, I'm getting sued, garnished, or just dealing with a lot of debt and stress, and you just need that peace of mind that the fresh start that bankruptcy offers. A lot of people will come to me here in my law practice in Arizona and ask, what are some of the things I need to consider when determining when I should actually take that next step? So I want to give you 4 of them that are very important to understand because they could impact your case in a huge way. Now, the first one is kind of a jurisdictional thing, and it's pretty simple. You can only file bankruptcy in a state that you've lived in for at least 91 days. Now, I know this kind of sounds obscure, but what the bankruptcy code says is you have to file in the place where you've lived the better part of the last 180 days. So the court said you got to live in that state for at least 91 days. In my law practice, I've had this happen several times where people have moved to Arizona, they've lived here for a month, maybe 2 months, and they're saying, you know what, with this move and kind of a fresh start here, I just want to start over completely, get rid of this debt once and for all. You have to live in a state at least 91 days. So, for example, if you came from California to Arizona and you've only lived here for 60 days, if you want to file bankruptcy quickly, you're going to have to go back to California and file it there, or you can just wait 91 days and file it in the state of Arizona. So the first one's really simple. If you've lived in the state where you're at for at least 91 days, you're good to go, at least as far as the first step goes. Now, the second consideration is we look at, again, how long you've lived in your particular state. Because in order to use the exemption laws in the state that you're currently living in, you have to have lived there for at least 2 years. If you haven't lived in your current state for 2 years, you have to use the exemption laws from the state that you came from. Now, the exemption laws, why these are so important is because these are the laws that protect your stuff as you go through bankruptcy. The idea behind a Chapter 7 bankruptcy is it's going to wipe out all that credit card debt, medical bills, but then the court's going to look to see, do you have assets that can be sold with the proceeds given to your creditors? Most assets are protected. There are different exemption laws that protect your things. Like most people have heard of like the homestead exemption. The homestead exemption in Arizona protects up to $250,000 of equity in your home. There's also exemptions for cars. Like for a vehicle in Arizona, it protects $6,000 of equity in a vehicle, and for household goods and retirement accounts and all that kind of stuff. Well, each state has their own set of exemption laws. So while a state like Arizona has a homestead exemption of $250,000 of equity, surprisingly, there's states back east, in particular, where the exemption is surprisingly small. I've seen it as low as like $15,000, $20,000 of equity is protected. So where this comes into play, let's say that you moved from somewhere on the East Coast, you moved to Arizona, you've been here for less than 2 years. So if you move here and you have $100,000 of equity in your home, under Arizona law, you'd be great, but we can't use Arizona law if you haven't lived here for 2 years. We have to use the law where you came from. And if the number is much less than that, you run the risk of losing an asset. So I know that gets a little bit complicated, but it can make a big difference as far as what assets you can keep and what assets that you're going to have to get rid of or are at least at risk of being sold through your bankruptcy process, depending on how long you've lived in the state. Now, if you've lived in Arizona for at least 2 years, you can file here jurisdictionally, and 2, we can use the Arizona exemption laws. This can get a little bit tricky, so if you haven't lived in the current state where you are now for more than 2 years, highly recommend you talk to a bankruptcy attorney so they can help you do that analysis as far as which exemption laws you can use and if you run the risk of losing any particular type of assets. So the third consideration as far as timing relates to what are called preferential payments. Preferential payments are payments that are made to what are called insiders. These are family members, friends, business associates. If you've loaned money from a family member or a friend and you've been making payments on it, the court can look at those payments that you've made in the 12 months prior to filing of your bankruptcy case, and they can call those payments preferences, meaning you're preferring your family member, your friend, maybe over other creditors. And if you file bankruptcy with a bunch of preferential payments out there, the bankruptcy trustee can go and get those funds back from whoever you paid them into, bring them into the bankruptcy, and then distribute them evenly or pro rata amongst all of your creditors. So if you have been paying back a family member for any time within the last 12 months, one, you ought to look at how much it is, and two, how many total months, because you may want to delay your bankruptcy filing until it's been more than a year since those payments have made. Again, this is an area where you really want to talk to a bankruptcy attorney, because I've had clients here in Arizona that I've met with where there's been payments that have gone back to a family member or friend on a loan that they had, but the amount was minimal. It was under $500, or it's something that was just recent. Maybe there's only been 1 or 2 payments. Those types of things can generally be dealt with, but if you just paid back 15, 20 grand to a family member over the last year, you really ought to talk to an attorney before jumping into a Chapter 7, because that could cause some problems where they're going to go back to that family member and ask for that money back, and Thanksgiving will be forever awkward after that. So this is one to really make sure you disclose to your attorney and then try to work through that, and it can impact the timing just because you may want to delay the timing until that year has gone by. The fourth thing to consider as far as when to file the bankruptcy is due to what we call fraudulent transfers. Now this sounds horrible on the outset. Generally the intent is not as bad as what it sounds like. But a fraudulent transfer is where there is a transfer of assets out of your name within the 2 years prior to filing bankruptcy. So let's say, for example, that you had a car and it's paid for, and you got to go into bankruptcy, you're worried about losing it, so you transfer it over to your brother. Your brother's not buying it, you're just transferring it over to them. If that's the case and you file bankruptcy, then that bankruptcy trustee can go put it back in your name and then determine if they can sell it for the benefit of your creditors. Now, where I see this happen the most often, it's super innocent. Generally families who have like teenage kids, where you go out, you buy a car, you put it in mom and dad's name when they're 16 or 17, and then when they turn 18, you transfer it over to them. Even that situation can be dealt with sometimes, and you can still move forward on your bankruptcy, but it's absolutely something that needs to be raised to the attention of your bankruptcy attorney, just to make sure that there's not going to be an issue, or if there is, that you may want to do the delay in filing. This applies to all type of assets, houses, cars, land, all that kind of stuff. If there's any type of transfer that occurred within that 2 years, it's got to be disclosed. Your attorney needs to really go through it with a fine-tooth comb just to make sure if you're protected before you jump into a Chapter 7 bankruptcy. Hopefully that's helpful. Those are 4 considerations that you need to make as far as the timing of your bankruptcy. 1, have you lived in the state at least 91 days? 2, if it's less than 2 years, you really need to look and see what exemption laws you're going to be using. 3rd, preferential payments. And 4th is fraudulent transfers. If you're looking for needing to file for bankruptcy, you're just wanting to know if it's a good option, and you're in the state of Arizona, I do free consultations. I'm not licensed anywhere else, so I can only do that for Arizona people, but I'm happy to take a look at it and determine really what the best option is to deal with your debt problem. My contact information is below. Thanks for watching today.